We are live this morning for a Justice Department conference on free speech in higher education with opening remarks from Attorney General Jeff Sessions. That'll be followed by a number of panel discussions with attorneys, college professors, and officials from the Justice Department. Live coverage on C-SPAN 2.
Good morning and welcome to the United States Department of Justice and our Forum on Free Speech in Higher Education. My name is Jesse Panuccio. I am the Acting Associate Attorney General of the United States. I will be your MC today as we hear from scholars, students, advocates, and policymakers who are committed to defending the fundamental right of free speech. We are privileged to be joined this morning by the Attorney General of the United States, Jeff Sessions, and John Gore, the Acting Assistant Attorney General for the Civil Rights Division. We will hear from both of them a little later this morning. Before we get to their remarks, please join me in rising to honor our country and our flag with the singing of the national anthem by Rhea Walker from the Office of Justice Programs. Rhea?
Oh, say, can you see by the dawn's early light what so proudly we hailed at the twilight's last gleaming, whose broad stripes and bright stars through the perilous fight o'er the ramparts we watched were so gallantly streaming, and the rockets' red glare, the bombs bursting in air, gave proof through the night that our flag was still there. Oh, say does that star-spangled banner yet wave o'er the land of the free and the home of the brave?
Thank you, Rhea. Thank you very much for sharing your wonderful voice with us this morning. That was a moving rendition of our national anthem. And many thanks to all of you who have joined us today and to C-SPAN for broadcasting this forum so that Americans at home can watch as we discuss free speech in higher education. It is a fitting day for this free speech forum, as it is Constitution Day. This federal observance marks the anniversary of the signing of the Constitution by the delegates to the Philadelphia Convention, some 231 years ago on September 17th, 1787. That seminal moment is captured in one of the panel paintings found just outside this great hall, paintings which commemorate the great codifiers of the law. This particular painting, simply entitled Constitution, depicts 8 of the founders signing our governing document. The person depicted furthest to the left is James Wilson, one of the few founders who signed both the Declaration of Independence and the Constitution. One of the most prominent lawyers of his day, Wilson was an indispensable figure at the convention, having addressed it 168 times to share his insights on political theory. In setting the stage for today's discussions, I think it is useful to ponder 2 thoughts championed by Wilson during his career. First, Wilson was a great proponent of popular sovereignty, the idea that the people, and not any official or government body, are the ultimate power in a just society. You might think it odd for me to invoke Wilson at a forum on free speech because, like many Federalists, he originally opposed the Bill of Rights. But he opposed them because he thought it unnecessary to guarantee pre-existing rights that a limited federal government had no power to constrain in the first place. And indeed, Wilson had good reason to believe the right to free speech was already deeply ingrained in founding-era America. As Yale Law School professor Akhil Amar put it in a 2010 article, American-style popular sovereignty should be understood to entail a muscular right of citizens to discuss political ideas and political proposals among themselves. In actual fact, the Constitution was born in a land awash with speech and through a process that teemed with talk of the freest sort, including lots of talk, harshly critical of existing officials and institutions, in an extraordinary efflorescence of accusations and addresses, analysis, arguments, books, cartoons, conversations and debates, disquisitions and essays, harangues, insults, letters, pamphlets, petitions, prayers, sermons, and writings of every sort, Americans in the enactment process itself exercised and exemplified an amazingly vigorous freedom of speech. Thus, as Professor Amar shows, the rock that Wilson's American Republic was built upon was free and robust speech. His conception of popular sovereignty would only work if all perspectives could be aired. Indeed, Wilson supported the separation of powers and other structural restraints found in the Constitution because he thought they would introduce more viewpoints into the legislative process, thus tempering the worst passions of majoritarian government. All of this is to say that we celebrate free speech as a right guaranteed by the First Amendment, but the amendment itself speaks of the freedom of speech, suggesting that the right was pre-existing. Indeed, according to Wilson, it was a precondition of the American Republic. So that is the first strand in Wilson's thinking that I think is helpful in framing today's discussions. America, from its founding, succeeded because its people were free to speak and to debate. The second strand in Wilson's thinking comes from his role as a professor. In addition to his service as a lawyer, a statesman, and later a Supreme Court justice, Wilson was an academic. When he immigrated to the Pennsylvania colony in 1766, he became a teacher at the College of Philadelphia, what is now the University of Pennsylvania. Later, after the Constitutional Convention, he became the school's first professor of law, delivering a series of lectures that the UPenn Law School today cites as its official beginning. In one of those lectures, in 1791, the same year the First Amendment was ratified, Wilson stated, quote, "In every government which is not altogether despotical, the institution of youth is of some public consequence. In republican government, it is of the greatest. Of no class of citizens can the education be of more public consequence than that of those who are destined to take an active part in public affairs." End quote. In other words, Wilson felt that a republic must recreate itself by educating each generation anew, especially those citizens who would take an active part in public affairs. Put this together with Wilson's view that popular sovereignty required free and robust debate, and it follows that educating good citizens meant educating them to participate in, uphold, cherish, and further the debate necessary for effective self-government. Indeed, one of Wilson's fellow founders, Thomas Jefferson, explained the issue this way: "In a republican nation whose citizens are to be led by reason and persuasion and not by force, the art of reasoning becomes of first importance." No wonder then that Jefferson, as he founded the University of Virginia, committed in a letter of 1820 that the institution would, quote, "be based on the illimitable freedom of the human mind, and its residents would not be afraid to follow truth wherever it may lead, nor tolerate any error so long as reason is left free to combat it." The last portion of that quotation is critical. To tolerate any error so long as reason is left free to combat it. Jefferson was saying that we have the right to be wrong, and importantly, that there is nothing to fear in being wrong so long as reason is left free to combat it. That is, so long as we are free to speak in opposition to an error. These founding era principles demonstrate the relationship between education of citizens and the thriving of the Republic. And they show why American society at large needs to be deeply concerned with the growing anti-free speech movement in the modern academy. The students who indicate in polls that they do not value free speech, the students who shout down or violently shut down speech, the students who simply are not exposed to dissenting viewpoints, will all soon be the voting public and the leaders of American society. Put bluntly, students will not become good citizens if they do not learn how to maturely interact in a pluralistic society. That is why the current academic movement that permits or encouraging the silencing of opposing viewpoints in myriad ways on campus is so urgently worrisome. It is not just depriving students of the best possible education. It is not just depriving scholars of academic freedom. It threatens to deprive American society of a new generation of citizens who, like their forebears, share a deep and abiding commitment to the free speech and the liberty it guarantees. What is happening on campuses today is simply toxic to our nation's future. And that is why, starting with the Attorney General's Georgetown address last year, the Department of Justice has been fighting for free speech on American campuses. As you can see here today, we are using the department's bully pulpit to raise awareness. And as appropriate, we are getting involved in litigation against state-run universities that violate free speech rights, whether through speech codes, so-called speech zones, or encouragement or acquiescence in the heckler's veto. Let me be clear. This is not an issue of partisan politics. Speech suppression by those on the right is just as inexcusable as speech suppression by those on the left. It was just as wrong for conservative protesters at Whittier College to shut down left-leaning state officials as it was for liberal protesters at CUNY Law to shout down a conservative law professor, or for protesters at William & Mary to shut down an ACLU speaker attempting to discuss, of all things, the importance of free speech on campus. This is not about political parties or a single policy debate. This is an issue of who we are as a country and who we want to be in the future. There are those who contend certain speech isn't deserving of protection. They say that some speech is harmful. But who is to decide what is offensive and what is favorable, what is grating and what is good? The right of free speech does not exist to protect the ideas upon which we all agree at a moment in time. It presupposes that the wheel will turn and turn again, that the majority view will change, and that when it does, those newly in the minority will still be as free as the day before to speak and change minds, to listen and have their minds changed. And so, as Justice Brandeis eloquently stated in 1927 in Whitney versus California, if there be time to expose through discussion the falsehoods and fallacies, to avert the evil by the processes of education, the remedy to be applied is more speech, not enforced silence. The Department of Justice is getting involved in the issues of campus speech because part of our role is to defend the Constitution and the rule of law. But we cannot do it alone. If free speech on campus is to survive, it is up to the campus community to sustain it. The students, parents, donors, and taxpayers who fund schools must demand it. The deans, administrators, presidents, and trustees who run schools must display the courage necessary to protect it. Every college president and every dean who holds their school out to be one of broad-based liberal arts education should put out a letter like the one penned by Dean Ellison at the University of Chicago, in which he explained to incoming students that the school would not be one where, quote, individuals can retreat from ideas and perspectives at odds from their own, end quote. In short, we need more voices standing up right now to protect free speech on campus. Happily, we are joined today by some of those voices. The distinguished speakers and panelists who join us today come to us from academia, nonprofits, and government. They are politically and intellectually diverse, yet they are all committed to the cause of free expression in higher education. We are grateful to each of them for providing a model of what a thoughtful, civil conversation about free expression can look like. We hope this conversation will continue across the nation and on our campuses and in the public sphere. This is an important event for the Department of Justice, and we are honored that all of these guests and each of you have joined us today. We expect a fascinating and productive day. We are also thankful for the department employees who made this event a reality. Rachel Tucker in the Office of the Attorney General, Rachel Bissix and Reed Rubenstein in the Office of the Associate Attorney General, Tara Helfman in the Civil Rights Division, Becky Rose and her team from the Office of Justice Programs, and Glenn Kivlin and his team from the Justice Management Division. With that, I now have the pleasure of welcoming to the podium Acting Assistant Attorney General John Gore, who will introduce the Attorney General. John has been with us since day one of the administration, and before that, he was a partner in the Jones Day law firm here in Washington, D.C. Here at the department, John's office handles some of our most challenging cases and issues. Under his leadership, the Civil Rights Division has launched several major and important initiatives, including the filing of the statements of interest in campus free speech cases. John, it's a pleasure to be your colleague. Thank you for joining us this morning. The podium is yours.
Thank you, Jesse, for that kind introduction and for your strong leadership here at the department. And let me just say right back to you, it's a pleasure to be your colleague as well. On this Constitution Day, let us take a moment to ponder the sheer enormity of the revolution that our founding fathers enshrined in the First Amendment of the Constitution. At the time of the founding, no country on earth guaranteed in writing the freedom of religion, speech, press, assembly, or petition. At the time of the founding, no country on earth was governed by a free and equal people. And at the time of the founding, no government on earth derived its just powers from the consent of the governed. Today, 231 years later, the grand American experiment of democracy and free government has changed the world. The Constitution has freed the human mind from tyranny and shielded the human conscience against government indoctrination, intrusion, and interference. The Constitution has raised the United States to singular heights as a free, fair, and prosperous nation. And the Constitution has sparked a global revolution in government's relationship to the governed and stood as a beacon, enlightening the human experience in nations and for peoples all around the world. The First Amendment was perhaps the Founding Fathers' boldest and most essential masterstroke. The Founding Fathers guaranteed all of the freedoms of religion, speech, press, assembly, and petition. The founders recognized that without these first freedoms, there could be no freedom of conscience, and that without the freedom of conscience, there could be no government by a free people, of a free people, or for a free people. As Benjamin Franklin observed, freedom of speech is a principal pillar of free government. When this support is taken away, the foundation of a constitutional society is diminished, and tyranny is erected on its ruins. That is one of the most important lessons of our constitutional experience. The First Amendment performs its most vital function whenever those in power seek to preserve their power by suppressing speech. That was true in the earliest days of the Republic when the Alien and Sedition Acts criminalized criticism of the federal government. It was true during the Cold War when so-called subversives were removed from public institutions because of their private political views. And it was even true during the Civil Rights Movement when judges issued blanket injunctions to silence and even jail civil rights activists. Today, the country faces a new challenge to free speech in a new forum. Ironically, this forum once served as the incubator of free speech, but today it far too often has become an inhibitor on free and open discourse. I speak, of course, of institutions of higher education. Those institutions are charged with the sacred duty of preparing each new generation of young Americans for a lifetime of active and engaged citizenship. But in recent years, some overreaching administrators and ideologically motivated faculty have abused their positions of authority, and they've chosen to act as censors rather than as pedagogues. Words, they argue, are as injurious as physical blows. Ideas, they contend, are as dangerous as weapons. Speech, they say, is hurtful precisely because it can raise hard questions. Instead of empowering students to enlighten their minds in the marketplace of ideas, these misguided administrators and faculty have enfeebled students to seek refuge from intellectual debate in the confines of campus speech codes. The First Amendment demands better. It demands eternal vigilance in safeguarding free speech through all political fads and fashions of the day. It demands eternal vigilance in safeguarding free speech, regardless of public clamor or private comfort. And it demands eternal vigilance in safeguarding free speech blind to party, philosophy, ideology, or belief. The Civil Rights Division and the Department of Justice are resolutely committed to upholding the First Amendment's first freedoms in our university and college communities. Our goal is to ensure that college students, faculty and administrators and student groups remain free to engage in the open and robust exchange of ideas at the bedrock of our constitutional system. The department's powers to engage in this debate and to pursue this goal are powerful but limited. Congress has authorized us to file statements of interest in First Amendment cases brought by individuals challenging unconstitutional campus speech codes. To date, we have filed 4 such statements of interest. We remain on the lookout for more cases and ask you to bring those cases to us if you have them. Now, some may be skeptical of the division's motives, or skeptical of the cases in which we've gotten involved, or skeptical about whether this is really some kind of political or partisan stunt. But to you I say, the simple brilliance of the First Amendment is its unyielding universality. Whenever the First Amendment protects the speech of any ideology, it protects the speech of all ideologies. It is no less repugnant to the First Amendment when a junior college in Joliet, Illinois, tells a socialist student that she's not allowed to distribute anti-capitalist flyers on campus than it is when a community college in Los Angeles tells a libertarian student that he's not allowed to distribute copies of the Constitution. We filed a statement of interest in the Los Angeles case opposing the college's motion to dismiss. The Joliet case, however, was settled by the parties before our opportunity to file a statement arose. But regardless of the case and regardless of the circumstance and regardless of public clamor, we in the Civil Rights Division are honored to stand on the side of the First Amendment on behalf of students, faculty, administrators, staff, groups, and anyone else whose free speech has been stymied, stifled, suppressed, or sanctioned by campus speech codes. Together, we can restore the grand tradition of open and elevated discourse on campus, and we can make our university and college communities more free, more fair, more open, more equal, and more just. We at the Department of Justice are honored to be led in all of these efforts by an exemplary and esteemed public servant. Throughout his career, Attorney General Sessions has fought for the First Amendment's first freedoms on behalf of all Americans. Today, he leads the department with uncompromising principle and undaunted integrity. Please join me in welcoming the 84th Attorney General of the United States, the Honorable Jeff Sessions.
Thank you. Thank you, John and Jesse. Thank you very much. Those are really valuable insights and comments, I think, that go to the core of who we are as Americans. And John Gore, thank you for your leadership at the Civil Rights Division. And Jesse, we thank you as our number 3 in the department, the leadership you're giving to us here every day. So we look forward to the panels that will be going on later today. I understand my friend Heather McDonald, who's has such tremendous insight into crime and punishment in America. Nadine Strawson, always principled and challenging former president of the ACLU, will be our keynote speaker. And I'm looking forward to the afternoon's conversation between Deputy Attorney General Rod Rosenstein and my good friend and former Secretary of Education, Senator Lamar Alexander. Among other things, Lamar is a lawyer, clerk for the great Judge John Minor Wisdom, and also served as president of the University of Tennessee, who used to have a football team. I'm not too sure about that, but and Rod is so talented, 28 years in the department, Wharton and Harvard graduate. So there's a lot to celebrate today. This is Constitution Day. I'd like to ask you to indulge me in a few thoughts. We have the oldest written Constitution still in use, 231 years. This brilliant document has stood the test of time. It has produced the most durable government because it is based on the founders' deep understanding of human nature, understanding of power, and understanding of law. This understanding did not arise out of thin air, but it was a product of centuries of development. The founders sought to create a government that made good decisions, which they believed could only arise if they were founded on truth. The First Amendment guaranteed freedom of religion, speech, assembly, petition, press. These weren't just words, not just words. They were fiercely held views. In many ways encapsulated the developing thought of the time and arose from some very specific grievances the colonies had. So the founders protected the liberty of Americans to express themselves. It was a core value of the new republic. They believed that from competing ideas, good ideas would dominate the false. Congress allowed prolonged debate. It's one of the things that they did. They allowed, in the Senate, really long debate. and they protected members of Congress from libel laws. And jury trials, for example, allowed witnesses and allowed them to be cross-examined in public. The goal was for objective jurors to find the facts and render true verdicts. The passion for justice has been a part of American life from the beginning, but we acknowledge that the principle has suffered at times over the centuries. From the Alien and Sedition Acts to slavery and segregation to religious and non-religious oppression, there have been pendulum swings that threatened our freedoms. But Madison was clear. He said freedom of speech is, quote, the only effectual guardian of every other right. But each time free expression has been curtailed, the founding principles recovered. Today, freedom of speech and thought have come most under attack on the college campuses. That should shock us. The words of the founder of the University of Virginia, as chiseled in his monument nearby, declare, quote, "For I have sworn on the altar of God eternal hostility against every form of tyranny over the mind of man." This was the vibrant spirit of our founders. May we not depart from it. But many are departing from these principles, or perhaps most dangerously, they have abandoned principle and truth altogether. If that is so, then they have chosen politics, ideology, passion, and power over principle, over law. When one exalts ideology and power, then suppression of opposing voices can be justified. But this is not America. This is not the way we were raised. And ideology and power politics are not law. They are the very opposite of law, in fact. As Americans, we know that it's far better to have a messy and contentious debate than to suppress the voices of dissenters, even though on occasion we might forget these values. As Senator McConnell often says, our history in America is of a teeming cauldron of competing ideas from the very beginning. Make no mistake, this Department of Justice is concerned about the suppression of speech that is now occurring. Defending the Constitution, defending civil rights, doing justice compels this Department of Justice to defend the right of speech, expression, religion, press, petition, and assembly. And defend these rights we will. And the most important time to defend a valued right is when it is being attacked or eroded. So last year, the Foundation for Individual Rights in Education surveyed 450 colleges and universities and found that 40% maintain speech codes that substantially infringe on constitutionally protected rights. Of the public colleges surveyed, which are legally bound by the First Amendment, fully one-third had written policies banning disfavored speech. So we are protecting the rights of students and free Americans, and we've been winning. I'd like to briefly mention a few examples. The University of California, Berkeley, the home of the 1960s free speech movement. I remember that. I don't know if many in this audience do. Allegedly applied a stricter set of rules for inviting public speakers to conservative student organizations than other campus groups. A group of students filed suit contending the school effectively discriminated against them and their right to speak. The department got involved and we filed a statement of interest in the case. Last March, a student filed suit against Pierce College in Los Angeles, alleging that the college prohibited him from distributing copies of the Constitution on Constitution Day. That seems pretty horrible to me. And outside of the designated free speech zone on campus. How big was this free speech zone? 616 square feet, barely the size of a couple of dorm rooms. Outside that space, students did not have freedom of speech on a public university. The student sued, and we filed a statement of interest on his behalf. Georgia's Gwinnett College allegedly limited free speech to just 15 ten-thousandths of 1% of the campus. Even within that tiny area, students had to get permission from campus officials in advance to speak. They could only use the free speech zones at a specific time, and they could not say things that might, quote, disturb the comfort of persons, close quote. In other words, free speech at Gwinnett College was a very limited privilege, not a right, even inside the free speech zone. If disturbing someone's comfort is the standard for banning speech, then anybody can stop anyone else from speaking their mind by acting offended. This is nowhere close to a legitimate First Amendment standard. Every great political leader in this country has disturbed the comfort of persons. Abraham Lincoln disturbed the comfort of slave owners. Dr. Martin Luther King disturbed the comfort of segregationists. Susan B. Anthony disturbed the comfort of quite a number of people. Change has never been effected without disturbing the comfort of persons, and likely never will. So the Department of Justice filed a statement of interest in this case as well. In each of the cases I've mentioned, the courts have agreed with us. Attempts to dismiss two of the cases I've mentioned have been denied by judges who adopted the department's positions. A third was dismissed only because the college changed its speech policy, rendering the case moot. At the end of May, we also filed a statement of interest in a lawsuit against the University of Michigan. The university sought to forbid harassment and bullying and actions motivated by bias. They also forbade speech that is interpreted to be demeaning, bothersome, or hurtful. But the rules did not give clear definition about what any of these terms mean. These rules, it seems, are enforced by a group of campus bureaucrats and campus police with the Orwellian name of the Bias Response Team, BRT. Students are encouraged to report their complaints to the BRT, which presumably then investigates to see if the speech was bothersome to them. In the last school year, BRT logged more than 150 cases. Within days of our statement of interest, I'm pleased to say the university changed several of its speech policies, and I understand they'd been evaluating that prior to that filing. But this is a positive step, and I want to commend the university for making that change, and I'm pleased that the General Counsel for the University of Michigan is here today. Make no mistake, the issues you will be discussing today involve protected core liberties possessed by all Americans, even students. Those protections provided by our Constitution are of inestimable value. No third-level bureaucrat, committee, top official at any university has the power to take them away. This has gone too far. It must end. The country protects noisome assembly, immoderate speech, provocative speech. Whether left or right, suppression of competing voices is not the American way. We have reached a pivotal, perhaps even historic moment. It's time to stand up to the bullies on campus, bullies in our culture. There are radicals out there that have openly and systematically justified actions that would deny Americans the right to speak out against their favored ideological agenda. We must put an end to such nonsense. It's time to put a stake in its heart. We have to stand up to it, and we will do so resolutely. We are going to keep fighting for the great freedoms vouchsafed to the American people, and we will endeavor to do so according to the highest constitutional and legal standards, and we plan to keep winning. Thank you very much for joining us today, and we wish you every success in the meeting throughout the day. Thank you very much. Thank you.
Our thanks to Attorney General Sessions for those remarks and for his leadership on the issue of campus free speech. Thank you, John Gore, for your great remarks this morning. Please feel free to stand and stretch for just a moment while we prepare the first panel.